Peace and blessings, people. Paper Arrows, part 5. It's the Gizzard, the always the get Rizza, the Wizard, decking the boy Izza, Tizza, destined to get the winses and fences, clearing up all the lenses. One path is the way that I'm taking, getting closer to God in the tight situation. We're going to continue and finish off with the presentation of the Paper Arrow series. This will be part 5, started from page 56. Cannot force waiver. There are all types of laws in the commercial law statutes of each state code. There you will find that the judge cannot alter or ignore a statement of any kind, such as without prejudice on any document. No one can alter, remove, or ignore it. If they do, they waive their immunity because they denied you a right. A right cannot be forced into a waiver. Here is the law that states this: 15 United States Code section 1693L. Waiver of rights. Commercial statutes such as Title 15 U.S. Code section 1693L, headed as waiver of rights, states, no writing or other agreement between a consumer or any other person may contain any provision which constitutes a waiver of any right conferred or cause of action created by this subchapter. You cannot be coerced into waiving your rights. If you sign a document that has a waiver of rights on it, the document is void on its face. Nothing at all can force you into a waiver of your rights in commercial law. Traffic ticket is notice. A traffic ticket is a commercial agreement, a commercial instrument. It is patterned after the UCC. It is even called a notice. It has a demand for payment on there. It is a commercial instrument and therefore comes under those laws. Criminal action. Under commercial law, they cannot force you to waive your rights. If they do in any way, shape, or form, or if they remove any such as a claim of rights, like without prejudice or all rights reserved, that you may write on the document, they may become liable under criminal statutes and the codes. They cannot deprive you of the right that you claimed, no matter what they say or how much they threaten or intimidate you. Sue them criminally. Rescission. There is a right of rescission involved in commercial transactions. The only way a rescission under commercial law can be done is when both parties consent to the rescission. Both parties have to sign the agreement of the rescission. Otherwise, it cannot be done. That means that you cannot rescind something on your own. You need an invitation from the other party agreeing that they will rescind something, like a signature. Operation of law. But under commercial law, anytime an obligor is established by the creation of a security interest agreement of any kind, and it arises under operation of law, which means contract or agreement, the law only operating after the contract or agreement is established, requires that the creator or maker of the instrument put on file or in writing to you, the obligee, that you have a fixed number of days, not less than 3, in which to rescind the agreement. If this is not in the agreement, then the agreement is revoked. Agreement revoked. Time period. Time period 2. Most agreements that are entered into by any of us do not contain any mention about the right that we have to be given a specific time period to rescind our signature, whether 3 days or 30 years. They just do not tell us that. All these commercial transactions are void on their face because of the lack of notice of the right to rescind, and even more of them are void on their face because they contain a waiver of rights in them. Waives rights. Mortgage. For an example, on the back of the first page of your mortgage document, somewhere close to the middle of the page, you will find a statement there that the borrower waives his right to presentment, dishonor, and protest. Those terms come right out of the UCC. Mortgage void. If you waive those rights, the mortgage is void. Remedy to revoke signature. Do not use this remedy unnecessarily. This could cause one heck of a mess in the banking system. But if you are losing your home or being put out of it, your family may be at the mercy of others. Then you could revoke your signature on the mortgage agreement because you were forced into a waiver that they are not allowed to do under the law. Now the lender does not have a signed agreement to present to the court to prove that they have a claim. We have used this process and the court has thrown the bank out. They dismissed their case from the court. The bank was foreclosing against a home where a wife and children will be on the street. It was necessary to take that action. The banks have lost every one of the cases where we have done this, and the people are not getting mortgage bills anymore. There is no mortgage. The deceptions are so intense that the wisest of men cannot know right from wrong. At one time, the Social Security system looked like the right thing to do, so I had no problem with joining. It was to be used as a way to take care of the elderly and me in later years. So we were told. But since I have found that it is just a way to confiscate my property and has nothing to do with taking care of older ones, it no longer looks like the right thing to do. What is right today may not look right tomorrow. Wall versus King. There was a case, what we just talked about, called Wall versus King. There was a case about what we just talked about called Wall versus King, 206 F. 2nd, 878. This is a civil rights action for a fellow who got a ticket for driving under the influence of alcohol. They suspended his driver's license. He said that was a deprivation of his property rights under the color of law. He filed a civil rights case. He lost. We can find more in cases that people lost than in the winning cases. When the case is lost, the reason is given in many of them. And then we can find out what not to do so that we do not commit the same mistakes and lose the same stupid way. Driver's license waived rights. The end of this case was that the end result of this case was that the court said that he had signed an agreement to get his driver's license. If he signed the agreement, then he knowingly waived any right that he would have that they could deprive by taking away what he got by signing the agreement. Suspending his license was part of the agreement if he did not follow the rules. He had agreed by signature to follow the rules, so they had the right to take his license. He did not lose anything. If you have a driver's license, you do not have a right. You waived it. Not told of waiver. Did you know that you were prompted into a waiver of rights by getting a driver's license? Did they have a good faith obligation to tell you that you were prompted into a waiver of rights by getting a driver's license, and that it was a privilege, that they were extending you, and that you were waiving all your natural rights by accepting the license? But they did not tell you that. Color of law action. In this case, they quote out of Civil Rights Key 1 from West Key Publication stating, action taken by state official in purported exercise of authority conferred by state is action under color of law. That means that any action at all taken by a state official under any state statute is an action done under color of law. Must counter original. This guy that we are talking about that filed a civil rights case because they took his driver's license away as a result of being given a ticket for DUI, lost the case because he did not show any fraud. He did not bring up any counter of any kind against the original agreement. I think we could take the same basic pattern of this case, work the fraud of the roads into this pattern of a case, and come up with the winner. But I do not have a reason to do this. They have not bothered me. I do not have any tickets for driving without a license. I might get one soon. Wall versus King. Complaint in Lynch versus HFC. Any of you that do have a ticket ought to consider using Wall versus King as the guideline and Lynch versus Household Finance. The last time I was down here, I brought what the lawyer had drawn up as a complaint in Lynch versus Household Finance. The lawyer was a young man just out of law school who took a real interest in his work and did a terrific job of putting the case together. It was very successful in the Supreme Court with the decision that came down in favor of the rights of the little people like us and Mr. Lynch. I think that is worth following. And if you follow that kind of a layout and work the details in accordance with the way this Wall versus King case goes into the function of the claims of fraud from the very beginning by the conversion of the roads, I think you'll be putting together a very interesting case against the cop or the judge or anyone else, such as the town, being it is a town cop. Address. By the way, if you sue the town or county, or if you sue the state, they are corporations. Corporations are artificial persons. They are fictions. They appear to be real persons, but they are not real at all. They have names and addresses just like other persons, but they are not human beings. Note, a human being does not have an address, but a corporation must have an address to exist. A human being may dwell or sojourn where he receives his mail, or he may choose not to be there at all, or he may choose to receive mail at many locations which have been assigned an address by the USPS, which is separate from the post office. Personal capacity, no immunity. Since they are persons, they have a political or business capacity and a personal capacity. So a corporation can be sued in its personal capacity for the actions that it may have done. Then it has no immunities. The corporate veil of protection is blown completely away by suing in its personal capacity. That is just like the government official's political immunity claims are blown completely away when you sue him in his personal capacity. So if you go after the town because the town cop wrote you a ticket, and if you put the kind of a case together that we just talked about, go after them in their personal capacities and include the cop and the town. It would be nice to be able to shut down some of these town governments. That would shut down zoning laws and all this building permit nonsense, and it would take an awful lot of pressure off the good American people. They would not have to pay so much. Close the government. The state would not get the money that it needs to pay back the debt that it owes. The debt would finally get so high that the state government would have to close. When that happens, the U.S. government would have to close. When they close the doors, the people will be free again, not tied to this enslavement of the giant systems of government. Paper arrows. Cases like these filed all around the country can help make these changes. They will be used like paper arrows to shoot into the courts to effect a fall similar to the Roman Empire. Shoot arrows straight at Babylon. Every time we hit the government with one of these cases, it is like hitting them with an arrow, and every one will wound them. Title 18, Section 242. There were mistakes made in another area years ago. The area was civil rights. We were led away from using the civil rights legislation available to us. We were led away by not wanting to be a part of the civil rights movement. All right, Title 18, Section 242. We went to the police department and asked the police to bring charges of deprivation of rights under the color of law under Title 18, Section 242 against another government official. They ignored us. So we went to the U.S. Attorney's Office and asked him. He ignored us. We never did figure out how to file a deprivation of rights under color of law, Title 18, Section 241 and 242 case. You have no right to do so. You have no authority to act. U.S. Attorney General. USCS Title 18, Section 242 mentions a case of a defendant who filed suit from within a jail. He was a prisoner. It states, persons to institute prosecution. Prisoner cannot properly personally institute criminal proceedings against state and its officers for violation of his rights under color of law. Any such complaint should have been sent to the U.S. Attorney General's office. This book did not say U.S. AG. It said U.S. Attorney. I got the court case used as a reference, and it specifically said the U.S. Attorney General. United States Attorney. So there must be a difference between U.S. Attorney and U.S. Attorney General. There is a big difference. The U.S. attorneys are the attorneys hired by and are on a retainer for the corporation known as the United States. The U.S. AG is completely different. The rules set up by Congress are completely different than for U.S. attorneys. There's a definite separation there. The U.S. Attorney General will act in cases that the U.S. Attorney will not even touch. There is a difference. You must send a complaint to the U.S. Attorney General's office. FBI. The case also noted that the U.S. Attorney General had the power to instigate an investigation of the complaint by the FBI. So the FBI will investigate your complaint of civil rights violations if it is filed with the U.S. Attorney General's office. Separate criminal complaint. So if you have a civil rights complaint under Title 42, Section 1983 in the civil arena, and you want to put a request for a criminal complaint to the U.S. Attorney General, these government officials are not anxious to be sued or to be charged with a criminal offense. Additional deprivation. If you put enough pressure on like this by the beginning to file some of these types of suits in a case that is really pressing you, they may well back off. They may also get a lot more nasty. If they do, you just write a second letter adding the nasty stuff that they have just done to you as an additional deprivation and try to force the issue for an investigation. If an investigation starts, that is when they will back off. We have gotten them in this position a couple of times. We have not been successful yet in getting them to actually act. They come up with weak excuses as to why the officer acted that way, or say it was only you or officer because of the lack of suits that come up like this. If there were more of these types of suits filed, they may have to take a more serious course of action against the government servants. More people need to file these type of complaints. Peonage. Under this ridiculous set of civil rights statutes stemming from the 13th and 14th Amendments, particularly the 13th, putting you in jail because you did not pay a debt is called peonage. There's a whole series of statutes in Title 18 USC called peonage laws. They start at Section 51. liable to you. There are lists of cases from about 1880 to 1991 that show that any party who puts you in jail for a debt is liable to you. It also says that they are criminally liable if the government wishes to proceed against them criminally if they put you in jail for a debt. Ticket from EPA is UCC. Dave DeRimer story. Dave had a piece of rental property with a leak in the septic tank that was reported to the government by his tenant. The government came out and wrote a ticket to Dave. The ticket looked like a traffic ticket, but it was from the EPA. The ticket of $125 was for not getting a permit to let the septic tank leak on the lawn, not because it leaked, but because he did not get a permit to let it leak. They did not sign the complaint. They just printed their names on it. The complaint has a space on it where the Justice of the Peace for Delaware courts is supposed to sign as a witness that the government agency signed the complaint. They did not sign it. They just printed their names, and it is doubtful whether they even went to the Justice of the Peace because he did not sign it either. The instrument is now lacking two of the requirements of the law. The government sent Dave notice of the complaint and a copy of it. So Dave sent a plumber and fixed the problem. No more leak. Sent another bill per UCC. The government flunkies decided to pursue the collection of the $125 owed on the ticket and sent him a second notice and said that he had to be in court. But the letter went back to the court unopened and stamped, returned to sender. So Dave never got the notice that he was supposed to be in court. But because he never showed up in court, the two flunkies filled out an application for a capias, and the judge of the common pleas court issued the capias. The capias is merely a warrant for arrest. It is an old common law approach to an arrest warrant. It was basically oriented around debt. Capias. In Delaware's law statute, it says that a capias will not be issued to any citizen or person in the state of Delaware unless first there are a precipice, judgment, and an affidavit in the court clerk's office stating that the debt is due and owing, and that the debtor is expected to abscond with anything of value or property that might be collectible. Dave owned several houses and was not any threat to flee over $125. They did not do the affidavit stating that the debt was due and owing. The law says that they will not issue the capias unless all three are on file. The affidavit has to be there, otherwise the capias will not be issued. The question arises as to why the judge would sign the capias if he knows the affidavit has to be there. This is there are several government officials bending the law here. They came out to Dave's house and wanted to execute the capias and arrest Dave. So they pulled out their guns and flashed them around in front of him and threatened to arrest him. He shut the door and called the clerk of the court and asked her if she would fax him everything that was on file in the clerk's office. She agreed to do that immediately, and with a friendly tone, she was a nice person, as most of them are. Affidavit must be filed. The affidavit was not in the file, so Dave advised them that they would be liable. They stated that they did not care. They would arrest him anyway. So Dave said that he was going to make them wait a little while for him to be arrested. The agent said that if he did not come with them immediately, they would call for help. They did just that, and the SWAT team came out. The regular state police showed up. The Lewis, Delaware police came out, and the ferry police from the ferry boat landing. There were about 100 cops on Dave's front lawn waiting for Dave to come out. In the meantime, the news media reported that there was a hostage situation. Dave liked it because he was getting news coverage, and the standoff went on for about 6 hours. The media had made a mistake about the situation and apologized and said that the police had him held up in the house and there were no hostages. But maybe they were correct. Dave was being held hostage by the police on his front lawn. Dave called us and then called a good friend who was a lawyer and never let any of us in. Lawyers were allowed in to talk to David Koresh at Waco. The lawyer told him to let the police arrest him and that it sounded as though Dave had an interesting case, so he did that. The police took him down to the station and then took him to the local county jail. The people at the county jail told him that there was a regulation that he had to take a blood test before they could let him in with the rest of the prisoners. They said they needed to know whether or not he had AIDS. Refused blood test. He refused to allow them to stick anything in his arm because he said they may give him AIDS if the needle was dirty, and now there was another standoff, and it went on for 5 weeks. Dave flatly refused to let them punch holes in his body and play around with his blood. So they put him in confinement away from the other prisoners. He had no telephone, no visitors, no mail, and no privileges. That was a mistake on our part. Dave had put himself in a position that he could not get in touch with us, and we could not get in touch with him from the outside. So we could not do any actions like the McLaughlin case that I talked about earlier because he refused to sign the document. He wanted to do the action and then instruct him how he should argue the case if he did get taken into court. If he did get taken into the court. With no communication, we could not do anything for Dave. Complaint by a prisoner. We decided not to let this happen again. There is a way to prevent this from taking place. The U.S. District Court will provide a form upon request known as instructions for filing a complaint by a prisoner under the Civil Rights Act, Title 42, are on one page. There are about 3 pages to fill in the blanks. These actions are very simple to do, especially for a prisoner. You fill in the blanks, answer the questions, and lay out your claim. You then ask for your relief and states, It states, do not enclose a brief. They will search the law for you. That is wonderful. Keep in mind that this is for a prisoner. They search the law and all that is needed for the prisoner to sign at the bottom. But that was the problem here. We could not get into Dave to sign the form. Prevention. To prevent this in the future, we all should have one of these forms signed and ready to go in case any of us get in the same predicament. It is placed where our family or friends can get hold of it. Now, if anything like that happens, they can fill it out with help from others if necessary and file it since it is already signed by the one in jail. We have discussed that we will file a McLaughlin case and refuse to sign any of the documents put in front of us by the police at the time of arrest or anything presented at the jail and demand a probable cause hearing. Then we will file the case because they did not give the probable cause hearing and we had not yet given consent by our signatures. So they will be holding us without probable cause. With all this time going by, in Dave's case, we decided he should go ahead and sign and file a counter complaint later because they did not have the affidavit from the Justice of the Peace we had mentioned earlier when affidavit missing. We also found out from a friendly judge that if the affidavit is missing, the state is liable and all the parties involved are liable for civil and criminal action. Now it must be put into a counter complaint. The jailhouse folks broke down some and we were able to get through to Dave and we told him what we thought he ought to do. We told him to go ahead and sign. He did, reserving all rights, and we bailed them out. Signing grants them jurisdiction. There is no right to a counter complaint unless they do have jurisdiction, so jurisdiction can be established in order to put in the counter complaint. This is touchy, but it will work. Denied motion to dismiss. We laid the groundwork for the counter complaint by following the rules and filing the proper motions. We had a hearing. Dave told her that the court did what I said they would do, what I said that they would do. They denied the motion to dismiss. That was good. They were playing right into our hands. We will get the judges in 3 courts involved. We will also get the state of Delaware, the 2 flunkies from the EPA, and 100 cops, plus the warden at the jail. Dave will be busy for a long time working on lawsuits, maybe a year or more. All of this would not have been necessary if we had already had the form with Dave's signature on it to file immediately when he was arrested. Prisoner. Injunctive relief. They claim that they will respond to a prisoner in 3 days, which is much faster than anyone else. For injunctive relief, they will respond with temporary injunctive relief in 3 days. If you want to get out because they have not proven probable cause and you want injunctive relief to let you out, they will let you out, provided that you agree that you will come back. If they say that they are going to end the injunctive relief, they just might end the relief. You never know what these clowns will do. They all seem to act differently. Allodial title. I want to talk about property and what to do about getting back deeds and such. Actually recovering the deed so that you end up with allodial title. Hold in due course. Section 3305 of the UCC, the rights of a hold in due course, says that means that all right to the property is in the hands of the holder of the instrument and not in the hands of the person named as the owner. You do not even have a right to claim anything on the property. The owner lost all of his right to the property. A deed is supposed to transfer title, not real. It never has been real. It goes with the property. In the ancient days, they picked up a handful of dirt and handed it to you. That handful represented the whole piece of the land that you were buying, and you were seized of the ownership of the property. People were so honest back then that you did not need to write up a document and file it in the government record. There was no thieving government to steal it. But the way it works now is the thieving government actually steals the right to the property away from you by getting you to file the deed in their records. Feudal title is limited title. That by making feudal title in England. The Roman Empire also destroyed it by feudal title. Feudal title meant limited title. At the pleasure of the king or of the Roman Empire, you were allowed to live on a property for a fixed period of time. The fixed period could vary from months to many years or even a lifetime. But at the end of the fixed time that the deed expressed that the property was to be used by you, the property reverted back to the king or the Roman Empire. They did not quite go that far in this country. There was at least a allodial title in this country. That was a reason that caused people to leave England and come here to America to own property and to have property rights. Allodial title. Allodial title meant that the piece of paper or whatever it was that identified the property was in your hands. No one else had any interest in the property in any way. They will have no interest in the rights, the use, or the time to be held by you. None of these things and others not mentioned were divided among two or more people. It was all actually seized in you, the one person. That was the allodial title. Today, if the holder of the instrument acquires the right of holder in due course, there is a shared ownership of the property, so it is no longer allodial. It does not matter whether it is done with a deed or with a land patent or any of the other things that people are finding to be filed in the records of the court. There are still ways that produce an instrument, and there is still a holder in due course, which has all the right in the property. There's no allodial title when the property is filed in the public records of the court. If you want a allodial title, you must get the title and the deed and any and all papers referring to that property out of the hands of anyone else and into your hands only. There is a way to do this. We should look up everything we can on the word color as it appears or is related to color of law in words and phrases from the shelf of the University of Maryland Law Dictionary. Color is defined very well. It also, colorable title is a title which gives the appearance that the title is in your hands, but it's not really there. It has the appearance of being the real thing, but it is not real at all. The deed that we have today that is filed in their hands and in our hands has the appearance that we have the ownership to the property, but they have the rights. We do not have all of the ownership. It is colorable. All deeds and title today are colorable. Defective conveyance. Colorable title, under which a good title may be acquired by average possession, means a writing which on its face purports to convey title to reality, but may not convey true title for want of title in grantor or because of defective mode of conveyance. Now they're grabbing a copy of the deed and putting it in their records, removing the right of property from you. It is a defect in the mode of conveyance. Along with the process of conveyance from me to you, when I sold my house to you and you bought it, an honest system would guarantee that everything that was there and all right, title, and interest to it conveyed to you when you paid me for it. Should is not must. So if some dirty lawyer comes along and takes the deed over and files it in the public record, he thinks he has done what he was required by law to do. The law states that it should be filed. It does not state that it must be filed. But the lawyer is a good government agent, and if it states that it should be filed, he will file it. He's looking for praise and a raise. He's trained to do what the government says. He's stealing the right of property from you, and is not aware that he's doing it. He's making the state an interested party in the property as holder in due course, and the state now has all the right to the property. Should be filed is expressed by the statutes because it's beneficial to the government if the claims are filed, but it does not say must. The government cannot become holder in due course if the claims are not filed. That is why the statute states that it should be filed. It is in the government's interest to be filed in public record in court. Defective conveyance. Since the state has all the right to the property, that is how they have an interest in it, and that is a defect in the conveyance. A part of what was just bought was immediately lost. This is what happens the first time the property is bought. The next time the property is bought it is automatic because of what the book stated in the sentence previously in the definition of color of title. which on its face purports to convey title to realty, but may not convey true title for want of title and grantor. Once this thing has been filed the first time and the right of title has been removed and it is sold to someone else, they do not get true title for want of the title not being in the seller's hands. It is in the hands of the state. Deeds were always held in the hands of the people before 1930. Now the deeds are filed in public record. There is no allodial title if it is filed in court. Now no one has true title to pass to the next buyer. It is being passed defectively due to the fact that it lacks the right of property, which is held by the state. True bank. This makes the court the true banks in this country. Look up the definition of bank in the law dictionary. A bank is a court. Adverse possession. It may be gotten back by adverse possession. All that needs to be done is to explain how this fraud was perpetrated, who did it, and that the holding due course now adversely holds the right to the property and that the true owner wants it back. There's also another way to get the deed back. The sheriff will go in and bring it out to you if it is done right. If the county holds your property and they put it up paid for the benefit, the purchaser paid for the property, paid the fee to the state so that they will accept the property and hold it for the purchaser. Then the purchaser pays rent to use the possession in a piece of property in which the state owns all of the right. The last two are known as filing fees and property taxes, respectively. The taxes or rent is paid over and over every year. It is paid just because it is filed. Notice and demand. It is not an honest act to manipulate property from anyone. You have the right to do something about that act. You could send the government a bill for the full value of the property. Since they are holding your property, let them know that you want them to pay you. Send them a notice and demand for payment. Ignore it. That is good. That is what you want. Send it by certified mail, process service, or courier. When you have proof that they have received it, you must give them about 30 days to respond to it. They must pay the bill or counterclaim that they do not owe the money and for a specific reason. If they fail to do either one of the two things just mentioned by the end of the 30 days, plus 5 days to allow for mail, send a second notice and demand for payment. Get proof of their receiving it. Give them 15 days to reply. They must respond. After the 15 days, give them another 5 days for the mail to be delivered. They must respond specifically, such as, you said that I owe you money for this reason. I do not owe you money for this reason because I do not have the deed in my hands. Just replying, I do not owe this, is not sufficient to answer a notice and demand for payment. They cannot answer that they do not have the deed in their hands because they do. So they will not answer. Every time they do not answer, you get to do the next step in the procedure. The next step in the procedure is to send them a notice of default with a copy of each of the first two notice of demand citations and the proof of service for each. That's called the notice of default. Rule 55, default. When they still ignore it, you must then go to the state court rule for your state. It will be called default. It is Rule 55 in the U.S. District Court rules. Default. There is no need to go in front of a judge. All that is required is an affidavit that the first and last notices were sent and the final demand was sent. The proofs of services must be in there too. Then you must write a request to the court that the court grant default judgment based on the affidavit. When these two steps are done, you go in for default judgment. There's always a fee to be paid judge. The court clerk will then send you up to the judge, and the judge will wait 30 more days. A copy of all this must be sent again to the person who is in default, making them aware that it is now in the hands of the court. They must petition the court. If they fail to petition the court for a hearing within 30 days, the judge will tell the court clerk that it is all right to sign the default judgment, and the clerk will do so according to law. Writ of execution. That's a process known as an administrative process. That's what that's called. So now we have a writ of execution. You still do not have much other than the decision you must then file. You still do not have much other than the decision. You must then file another complaint. It is called a request for a writ of execution. In some states, it must be a request for a writ of capias. The court clerk will provide the forms to petition the sheriff to execute the collection of the money or the property or whatever is named on the form. You will tell the sheriff to bring it back to you. He will follow the instructions. If you want the sheriff to go to the county's bank account to that, such as taking the deed to the property out of the court records and bring it to you, he will do that. If the first alternative is impossible, the deed must be taken out of the deed plat book and returned to you along with the UCC-1 forms that are in the vault that the lawyer filed when you bought the property. They no longer have holding due course rights in your real property. You own the land, have the title, and own all the property in the land. With the last part of the process, I'll stop right here again. Pardon me. The last part of that process is a part of the administrative process. It's all part of the administrative process, and this would be the part we're coming up to now are the letters for the administrative process. And then, of course, you will put your name on the top, a non-resident alien to all corporate governments. CO means care of, is where you pick up mail. You put the town, the state spelled out full, the zip America, and then the date. And this is called the notice of demand to a foreclosing lender. Notice and demand for exhibition of presentment without dishonor. Demand is hereby served in accordance with state and federal laws, statutes, and subsequent index codes that you produce the written authority granted to make anything but gold and silver coin attending payments of debts. And any which I agree to be held liable and chargeable to any bona fide valid claim of debt by me payable to your bank within 10 days from receipt of this notice and demand. Your fellow will be an admission of the fraud attempted to be perpetrated upon me by you and your agency bank. Specific performance by you as initially purported is an alternative. Silence can only be query left unanswered will be intentionally misleading. We cannot condone this shocking conduct. If that is the case, we hope our message is clear. This sort of deception will not be tolerated, and if this is routine, it should be corrected immediately. U.S. versus Twill, and that's a case from 1977. The continued silence by any failure to produce or to deny by your bank corporation strongly suggests the validity of my claim of my not being subject to bank debt claim forms. It will seem most appropriate for your counsel to review their erroneous position. Fraud vitiates the most solemn contracts, documents, and even judgments. U.S. versus Throckmorton, 98 U.S. 61 651. You have 10 days to respond sincerely. And you put your name, non-resident alien to all corporate governments, natural American human being. Now it's just care of, your name, care of, where you pick up mail, which would be your address, town, non-domestic, state name, America, and consent. To whom it may concern, I, you will put your name, of course, an inhabitant located in county name of your state, but not the corporate body politic of either, and a natural human being of the American Republic nation, do hereby revoke and make void per UCC section 2608, ab initio, all signatures on any instruments and any consent of express or implied power of attorney therewith, in fact or assumption, signed either by me or anyone acting as my agents or unsigned as it pertains to the stated, a birth certificate or marriage license, etc. Any and all certificates issued by name of department, governmental, quasi-governmental entities due to the use of various elements of fraud and misrepresentation, duress, coercion, mistake, or bankruptcy as per UCC section 1103 by said agencies, entities, I hereby cancel, repudiate, and refuse to accept any benefit, franchises, or privileges attached to the above mentioned items. I, of course, you put your name, do hereby revoke, cancel, annul, repeal, dismiss, obliterate, delete, nullify, efface, erase, expunge, excise, strike, repudiate, wipe out, disavow, recall, renounce, destroy, abjure, disclaim, disown, reject, and relinquish all signatures and powers of attorney, in fact or assumption, with or without my consent and or knowledge, as it pertains to any and all property, real or personal, tangible or intangible, corporeal or incorporeal, obtained in the past, present, or future. I am the sole and absolute possessor and owner and possesses absolute, unqualified, full right, allodial title to any and all such property as a member of the American Republic with no effectively connected trade or business within the United States or the state of Bali Politic Corporation. This instrument replaces, cancels, and repudiates the prior instrument filed by me or my agent with the government department office and any and all governmental entities anywhere which may execute on said prior instruments, and this document shall become a permanent part of the records of the above named government agency. All such instruments are without prejudice to me and non-assumption to you. Witness my hand this day of the month, the year, your name, three witnesses, the notice of default. And what it is, people, is basically, I'm gonna stop right here for a second and give some information. So the people have to basically get more knowledge on these procedures on what's taking place, because these are things that's not necessarily taught in school. So you have to, ignorance of the law is no excuse. So everybody should be versed in the law, because if you don't know your rights, then you don't have any. So right here we come upon what's called a notice of default, and it reads: you have defaulted and failed to reply or comply with the notice and demand for exhibition or presentment without dishonor filed on the date with this court regarding the above action in which demand was made to produce prior to hearing on that particular date, and that was April 14, 1993, your authorization by the state legislature to have made anything but gold and silver coin attending payment of debts. Copy and close. By your default, you have admitted that your lending institution, a false claim of now existing debt. Such false claim by you is a fraud being attempted to be perpetrated on me, us, while attempting to utilize the good offices of this court to collect such spurious and false debt claim. You have 5 days to cure the default, or I/we demand that you immediately return any and all property and or money stolen or otherwise collected unlawfully, and immediate removal of any levies, liens, mortgages, liens, and or notices of levies or liens. Further, I/we demand immediate return of any and all payments which we may have inadvertently made to you, your lending institution, based upon your admitted previous fraudulent claim of debt from the date of alleged inception of the alleged loan to today's date. Your failure to immediately complete restitution to me, us, as above, will be met with summons and complaint, both civil and criminal, in your personal as well as your corporate capacity in federal district court. Immediate compliance is demanded. You put the date. I believe that's him and his wife who filed this particular paperwork. So it says, after everything is returned, sue the lender anyway for damages ×3 under Title 42, Section 1983. Civil rights claims where government employees have exceeded their constitutional and civil legislative granted rights by depriving you of your unalienable, inherent, natural, God-given property rights as secured by the Constitution against infringement from government. Their questions, my answers, and reasons. Question: are you John Doe? Answer: no. I am not my name. My name and my body are two different entities. I can even change my name, but my body will be the same. Question: what is your address? Answer: I do not have an address. Only pieces of real property, land, the post office department. The address stays with a piece of property, even if the human being that stays there dies or moves to another piece of land with a different address. Okay, so this is actually questions, answer, and then R is the reasons. Yeah, Q is for the questions, like it says right here. The A will be for the answers, and then the R will be the reasons why you give these particular answers. Okay, so here's the question: where do you live? Answer: in my body. And the reason: life outside my body does not belong to me. I am alive in my body. I live in my body. This question: where's your home? Answer: abroad. The reason: my home is beyond the rule of arbitrary jurisdiction. It is beyond the seas. It is abroad. Question: what is your social security number? The answer: I do not have one. The reason: even if I'm carrying a social security card with a number on it, The number does not belong to me. It belongs to the Social Security Administration. It is their number and not mine. They allow me to use it if I choose, but not for purposes of identification. I choose to not use it. Using it is voluntary, and I volunteer not to use it. Now we come to another part of the book about some lawyers. You're about to read the names of 12 of the nation's most prominent lawyers. One of these men was a law school dropout. He quit law school before he was finished. He was not proud of it. See if you can guess his name. Patrick Henry passed his oral bar examinations in 1760 and within 3 years had handled more than 1,100 cases. He was a member of the Continental Congress and later governor of Virginia. John Jay was admitted to the bar in 1768, subsequently distinguishing himself from the first Chief Justice of the Supreme Court. John Marshall passed his bar exams. William Wirt was barely 20 when he practiced law in Culpeper County, Virginia, and he eventually became United States Attorney General. Roger Taney was admitted to practice in 1799, served as first Secretary of the Treasury, and then as Chief Justice of the Supreme Court. Daniel Webster was admitted to the Boston Bar in 1805 and established a phenomenal legal reputation, and also served as Secretary of State in 1841. Simon Chase gained his early prominence as a defense attorney for runaway slaves and also later became Chief Justice of the Supreme Court. Abraham Lincoln gained his experience as a lawyer and became the 16th President of the United States. Stephen Douglas was admitted to the bar in 1834. He later became a resident and then a senator from Illinois. He is best remembered for his debates with Lincoln. Clarence Darrow was a lawyer of world renown whose most famous case was the Scopes case, the so-called monkey trial in 1925. Robert Story was born in 1893 and served as president of the American Bar Association in 1952 and 1953. Strom Thurmond was admitted to the bar in 1930 and later became governor of South Carolina and then senator from that state. Remember that one of these distinguished gentlemen is a law school dropout. He abandoned law school after his first year and never returned. Clarence Darrow was that dropout. That is right, Clarence Darrow, the name that the entire world associates with the practice of law, attended law school for only 1 year. He did not distinguish himself by that and studied law on his own. In conclusion, it should be stated here that the other 11 distinguished American lawyers could not have dropped out of law school because they never went to law school at all. Remember this the next time a judge or a lawyer says to you that a man who represents himself as a fool for a client. And folks, we come to the end of the book. Titles of the United States Code, in particular code sections. Coming to the end of the book now. We're actually done with our reading. Yep, and we have just completed Paper Arrow series. I want to thank everybody who listened and take the time to read along with me. I mean, bear with me, people. This is the beginning of something real beautiful, and I'm going to continue to come here and read some of these beautiful documents that I come across. Thank you, people. Thank you, thank you, thank you for your time and your patience with me. Thank you, thank you, thank you. This is some preambles of the Articles of Confederation. To whom To all to whom these presents shall come, we, the undersigned delegates of the states affixed to our names, send greeting. Whereas the delegates of the United States of America in Congress assembled did on the 15th day of November in the year of our Lord 1777, in the second year of the independence of America, agree to certain articles of confederation and perpetual union between the states of New Hampshire, Massachusetts Bay, Rhode Island, and Providence, plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia. And then you have a preamble to the Constitution. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. We will establish this Constitution for the United States to draw up the Articles of Confederation. In only 6 years, they got together once again to amend the Articles of Confederation and ended up